Be ready. 5 seconds. It is a case in which the appellants had filed an appeal under Section 14A of the Scheduled Castes and the Scheduled Tribes (Prevention of Atrocities) Act 1989, challenging the order dated September 14, 2017, vide which the learned court below had taken cognizance of the matter and the appellants had been summoned to face trial. The order dated April 12, 2018, vide which bailable warrants had been issued against the appellants, was also challenged. Learned counsel for the appellants, while referring to an order passed by a single bench of this court in Criminal Appeal Defective number 523 of 2017, titled as Rohit versus State of UP and another, submitted that an appeal filed after expiry of period of limitation provided under Section 14A of the 1989 Act, can be converted into a bail application in exercise of inherent powers under Section 482 CRPC. As in the case in hand, the appeal was filed beyond 180 days, the same should be permitted to be converted into bail application and dealt with accordingly. On the other hand, learned counsel appearing for the respondents submitted that primarily all the questions, which have been referred to be considered by full bench of this court, have been answered by a full bench of this court in re provision of section 14A of SC/ST Prevention of Atrocities Amendment Act 2015. He further submitted that section 14A(3) of the 1989 Act, which provides period of limitation for filing an appeal and limited discretion in case of delay, has been struck down. Meaning thereby, an appeal against an order passed by the court below under the provisions of the 1989 Act, can be filed at any time. The judgment in Rohit's case as relied by learned counsel for the appellants, has specifically been overruled. This court cannot rewrite the provisions of law, the same have to be interpreted as such. To appreciate the arguments raised by learned counsel for the parties with reference to interpretation of section 14A of the 1989 Act, it would be appropriate to reproduce the aforesaid section hereunder, 14A. Appeals 1. Notwithstanding anything contained in the Code of Criminal Procedure 1973 (2 of 1974 an appeal shall lie, from any judgment, sentence or order, not being an interlocutory order, of a special court or an exclusive special court, to the High Court both on facts and on law. 2. Notwithstanding anything contained in subsection 3 of section 378 of the Code of Criminal Procedure, 1973 (2 of 1974 an appeal shall lie to the High Court against an order of the special court or the exclusive special court granting or refusing bail. The aforesaid section was inserted in the 1989 Act, vide Act number 1 of 2016, with effect from January 26, 2016. Subsection 1 thereof starts with non-obstante clause. It provides that notwithstanding anything contained in the Code of Criminal Procedure, an appeal shall lie, of a special court or an exclusive special court to the court concerned.